Never again will one generation of veterans abandon another. That is the founding principle of Vietnam Veterans of America, the congressionally chartered veteran service organization where I had the privilege of working for nearly 5 years. It was founded by anti-war protesters who were also warriors, women and men who fought in Vietnam and came home determined to make sure that the next generation of service members would not go through what they did. When I deployed more than 30 years later, I came home to a country shaped by their work. I came home to benefits that they fought for. I came home to a culture that had learned to separate the warrior from the war, so that even when the Iraq war that I fought in became deeply unpopular, the American people understood that a soldier following lawful orders was not at fault for the war that they fought in. That cultural shift didn't happen by accident. It happened because veterans chose an institution and took its side. By the time that I worked there, Vietnam Veterans America had spent nearly 50 years defending one of the most important institutions in American democracy, the Department of Veterans Affairs. The VA is the second largest cabinet-level department in the federal government. It operates the largest integrated healthcare system in the United States. It trains the majority of physicians in the U.S. It develops medical breakthroughs. It's where the first transplants happened. It serves as a backstop during national emergencies like pandemics and natural disasters. And it keeps promises made to the people sent to fight this country's wars. Most Americans think that the VA is failing. They remember the scandals, the wait time crisis, the headlines. What they don't hear about nearly as often is that veteran patient satisfaction consistently outpaces most private healthcare systems. They don't hear about the medical innovations that are being made and saving not just former soldiers' lives, but every American's life. They don't hear about the quiet, steady improvements that are being made day after day. Because if it bleeds, it leads. That's the way that our news and social media work. And there has always been a class of powerful people who would prefer to ruin the VA's reputation so that they can dismantle it. Not because it fails, but because it represents something dangerous to them. A functioning government-provided healthcare system that they can't profit off of unless it's privatized. During the first Trump administration, control of the VA was effectively steered by 3 wealthy Mar-a-Lago members who were not veterans, were not in government, but who took a keen interest in veterans' healthcare for their own reasons. Major, multi-billion-dollar contracts were influenced. Privatization proposals became law, and veterans' private medical data was discussed as a commodity to be sold, to profit off of. Meanwhile, a relatively small handful of veteran policy experts across organizations like VVA, Veterans of Foreign Wars, Disabled American Veterans, and others worked relentlessly to defend the institution. They didn't have the money. They didn't have the billionaire donors. But they specialized. They focused. They defended one thing, and they held the line. And they were effective. On Tyranny, Timothy Snyder's second chapter instructs us to defend institutions. He writes, "It is institutions that help us to preserve decency. They need our help as well. Do not speak of our institutions unless you make them yours by acting on their behalf. Institutions do not protect themselves. They fall one after another unless each is defended from the beginning. So choose an institution you care about, a court, a newspaper, a law, a labor union, and take its side." What I'm talking about here is what Snyder means when he tells us to defend institutions. Defending institutions doesn't mean trying to fight every battle everywhere all at once. It means choosing something you care about, something you understand, something where you can make an impact, and taking its side. Since returning to office, Donald Trump has sought to dismantle or hollow out as many institutions as possible, from USAID to the Department of Education, while simultaneously weaponizing federal power against his perceived political enemies. It would be easy to assume that the courts no longer matter, that the justice system is broken beyond repair, that accountability is a myth. But institutions do not defend themselves. They survive because of the helpers, because of the specialists, because of the people who chose to take their side. And today we're going to talk about one of those institutions, the federal courts. Right now, in district courtrooms around the country, judges are reviewing executive orders, immigration detention policies, and attempts by DHS and ICE to reinterpret decades of settled law. Much of the chaos that Trump has unleashed against this country using DHS and ICE hasn't been stopped, but a lot has. And this is a slow constitutional process. And the good guys don't always win everything, at least not right away. This is the rule of law under stress. And helping us understand what is actually happening in those courtrooms is someone who has chosen his institution and taken its side. Chris Geidner is the founder of Law Dork, one of the clearest, most disciplined legal publications covering the Supreme Court and federal litigation in real time. He has spent years making court decisions legible to the public and, when necessary, fighting for access to the very documents that allow citizens to hold the government accountable. Today, we're discussing ICE, DHS, refugee detention, executive power, and whether the courts are holding the constitutional line. Because if institutions fall one after another, it's not because they failed quietly. It's because too few people defended them early. Let's talk about what it means to defend institutions. While this discussion is about the courts and the power of journalism, as you're listening, I want for you to think about how the lessons you'll learn here apply to you and the institutions that you care about most. And then think about how you're going to go on offense for that institution. Chris Geidner of Law Dork, thank you so much for joining us. I'm someone who has followed you online for I don't even know how long. You are someone who has made what's happening in the courts more digestible for someone like me who didn't go to law school, who doesn't really understand a lot of the processes that are going on. And this is kind of something that I think most Americans had the privilege of being able to ignore for most of their lives. Your name is Law Dork because you're showing that you're not the average person, right? So if you could, please orient my audience to who you are and what it is you do with your publication.
Yeah, no, thanks so much for having me. I have been covering the courts off and on really since around 2000. I was working at a newspaper in Ohio, and then once I started law school in Columbus at Ohio State, I started Law Dork as a blog, and since then have practiced law, have worked in nonprofit, worked at the Supreme Court, covering cases there, also sort of covering broadly the sort of national legal landscape. And since for the past now more than 3 years, I've been doing that from Law Dork, the newest iteration of it, and covering essentially what is it that the courts are doing that are affecting ordinary people. And that, I started right before the Supreme Court overturned Roe versus Wade. So like a lot of the original coverage was focused on sort of the immediate aftermath of that. And then once Trump got reelected, for the past now 13 months and 8 days, have been covering the ins and outs of court hearings across the country, lawsuits, executive orders, up to the Supreme Court, from the shadow docket cases to the actual arguments and merits decisions that we've been getting.
Now, you're not just a passive observer. You've also taken action to ensure that that the public has the right to see what's going on behind closed doors, or behind what's going on with these many, many, many lawsuits against DHS. Can you kind of explain what it is that you're fighting for right now?
Yeah. So for the longest time, I mean, really since after I became a lawyer, when I've been doing this work, one of the like central elements of what I do is make sure that the documents that are a part of litigation are available to people. And that has two main purposes. The one is so that I'm accountable. Like, you don't have to take my word for it. You as a reader can look at the underlying opinion. You can look at the filing from the Justice Department. You can look at why plaintiffs are saying something violates the law. But then also it holds those people who are filing it accountable, because those are documents that, particularly when it comes to the government, that they're filing using our money in our name. And so they should be readily, easily accessible to the public. And so I have always had that as a big part of my work. And in Minnesota and in some other cases, there's a default federal rule that generally has not mattered in other iterations of our government, that if you have an immigration detention based case that has to do with either deportation or detention in immigration, it sort of, the default federal rule is that the filings, all of the court's orders are on the public docket that you can access from anywhere, the virtual online docket called PACER. But all of the filings from the parties, from both the government defending this action and the it's called a petitioner in these cases, the person who they're trying to detain or deport, are not public. They're not remotely public. You can go to the courthouse physically and get them if you are a journalist or a member of the public. But if you or I on a weekend, even if you were in Minnesota, wanted to get it, you couldn't. And so there was this, I thought, a rather important case challenging the treatment of refugees in Minnesota. On January 9th, the administration announced that they were starting a new operation that was going to try and essentially, building off of Trump's claims that Biden didn't sufficiently vet refugees, which, I mean, has its own, like, that's a lie. But like, putting that aside, the administration, like people at DHS and DOJ implementing that view, started this new revetting process. And as part of that, they said that they were going to revet, and it appeared potentially detain up to, they named 5,600 refugees in Minnesota alone. And they made it clear that this could go wider and affect other states, other locations. And so, but because of the format of these cases, because it was, the challenge to that was a challenge to detention of immigration, it was hard to get access to these documents. And so, what I did, once the judge in the case, Judge Tunham, issued a temporary restraining order for that class that said, and that was publicly accessible because it was an order from the court. What he said is DHS had to stop while he was considering this lawsuit. They had to release any refugees who had been detained under this process, and they had to stop arresting and detaining refugees under this process. Because of that, we were able to learn a little more about what was going on because he started ordering DOJ to produce memos. Now, I reached out to the lawyers involved and was able to get a hold of the memo without needing to go down to the courthouse because, again, they're public. It's not like it's sealed. It's not like these are like legally hidden documents. It's just that they're not publicly accessible. And what I found out when I got that is that back in December, DHS issued a 1-paragraph memo essentially saying we're withdrawing the guidance that's been in place since the Refugee Act of 1980 was passed, most recently expressed in a 2010 memo. So this has been, that memo had been the law now since 2010, and it was the policy of the federal government since 1980. That they were just going to reverse that in mid-December. And that's why they then had the basis to change this policy on January 9th. And what it was shocking. It is a policy that when you come into the country as a refugee, you are vetted before you come. This is not like asylum where you show up at the border. A refugee is abroad. They apply, they're vetted, they go through this whole process before they even come to America. Then, after a year in America, they can apply to adjust their status to lawful permanent resident. But they can't do that for a year. What the Trump administration is trying to say now is that starting on day 366, if they do not have LPR status, if they have not adjusted within that day, they are now subject to detention and arrest until that can be figured out. That, again, has not been the policy since the Refugee Act of 1980 was passed and was most recently laid out in the policy in 2010. We then sued. I worked with, I've written about this, and we essentially went to court and said, we would like you to change that default. I worked with Public Justice, nonprofit organization that works, nonprofit legal organization that works to among other things, to make courts, they have an entire project devoted to court transparency. And what we asked for was for that default rule to be changed, because in that default rule, non-lawyers might not understand that, when I say default rule, what that generally means in the law is that there's an option to change it. It's not that's what happens if you do nothing else. That's the way it goes. And the rule specifically says, unless a court declares otherwise. And so we were asking the court to declare otherwise. We've also asked, there was some potential sealing of documents that was going to be authorized in the case that we felt that DOJ hadn't even specifically asked for it. The judge didn't justify why these documents were going to be sealed. And then the third thing we asked for was a public access line so that members of the public could listen in on hearings if they weren't able to get into the courthouse. Ultimately, we technically lost all three requests, but the filing actually got us what we wanted. Just by filing the request, the judge issued an order before even ruling on our request to change the sealing. He said, basically said, like, the prior order that said that these documents can be filed under seal, no. They will not be filed under seal unless the government requests it, provides reasoning, I agree with it, and grant it. And so because of that, that is why we even learned about the one paragraph order, because it wasn't filed under seal. Then in denying our request, the magistrate judge basically said, like, there is public access because you can go to the court, and there is a media access line. And Law Dork is a credentialed media with the federal court in Minnesota. And so Law Dork is able to participate in arguments remotely. And so when the judge held the preliminary injunction hearing on February 19th, I was able to listen to it. And I think because we had filed this request, there was more attention on the case. And I wasn't alone on the hearing. There were, like, I think 11 or 12 other media outlets. I mean, there were local outlets, like I think Minnesota Public Radio probably would have been on the line regardless, but there were several national outlets on the line who I don't know if they would have been otherwise. And then, like, truthfully, because we filed the request, the lawyers in the case, I drew attention to myself from the plaintiff's lawyers in the case, who understood that I cared about it and provided me with filings when they were filed. Because again, they are public. It's not that they were doing something inappropriate. They're public documents. They're on the docket, but under the default rule, I, as an outside person, would not be able to go online to Pacer and just connect with it and download the document. I would need to physically go to the courthouse in Minnesota. And the other aspect of filing the case and having Law Dork and I have more than 80,000 subscribers. Like, literally a law professor in Minnesota reached out to me and was like, if you have problem getting the documents, I'm sure, like, one of my students can go down to the courthouse and get them. And so, like, it is one of those, like, filing the case got me everything I wanted. I still have a lot of, and once the case slows down, like, I want to write about, like, the reasons why I think there are some problems with the default rule in certain circumstances. But, like, what we were doing was sort of wanting to open this case to the public. And while we didn't get the relief we wanted, we did open the case. We drew attention to the case. And when the Judge Tunham, issued his preliminary injunction ruling last night, on Friday night, it got a lot of attention because people were aware of the case now. And while the Washington Post and CBS News tried to cover it without giving me any credit, that's fine.
Can you help me understand and help my audience understand why it is that people should care about this case in particular?
Go on.
I'm as a veteran, as someone from the veteran advocacy community who's worked in, the national security space. I'm a former lobbyist who used to interact with the Department of Defense, the Armed Services Committee, all these things, right? So I have been for years trying to convince people to care about refugee issues, particularly as it affects people in my position. Veterans who have gone overseas, who've made promises to people in a combat zone saying, we're going to take care of you if you take care of us. We understand your family's at risk, right? So that's a moral argument that I'm able to use from my own experience, but it's a relatively small sliver of refugees who we've made those promises for, people in Iraq, Afghanistan, Syria,
right,
etc. But can you help my audience understand why people should care about refugees and what's going on in this case specifically, what's being argued, and what's at stake for them?
Yeah, I mean, it really is an astounding situation. Like the reason why this is the position, has been the position of the government since the Reagan administration, and why it was almost not even understood to, like, there was no reason to think anybody would ever try to come up with the position that the Trump administration is now trying to advance, is that, like, the whole point of the refugee program is the opposite of what is being laid out by the Trump administration. The idea of the refugee program is to provide an opportunity for people who need it, who essentially prove themselves to the government as needing this protection, needing this this ability. And I think it was Judge Tunham, he issued this order and on Friday, and I think he really summed it up. He said, in the Refugee Act, this nation extended a helping hand to those escaping persecution. We made a simple promise: pass the vetting, follow the law, and you will be given a chance at a new beginning in safety. That promise was not symbolic, it was concrete. It meant the opportunity to work, to worship, to raise children without fear, and to build a future under the protection of American law. Stability, not more fear, was the commitment. The government's proposed new interpretation upends that commitment without clear authorization from Congress and rests on constitutionally precarious grounds. I mean, the whole idea is that, like, people come in and in their first year, like in their first year in America, they're adjusting. They're literally, they work with refugee relocation agencies. There is a whole process in place that they come into America. They are placed in a community where, like, sometimes, and this is, I think it is important to understand, like, in light of, like, the way Trump attacks, like, specifically, like, attacking the Somali community in Minnesota. Like, part of the way that we work with the refugee agencies, with the states that do it directly, is trying to help find refugees, like, communities where they actually will be able to find other refugees who have a similar background, have a similar experience, so that they can help integrate them into America. Like Trump uses it as a negative thing, and the whole point of this is that they are being integrated into America, and so they spend that first year, and then after a year they're able to go through the process to adjust to LPR status, which for a refugee is a more specific process, because they already went through the first vetting. If they meet certain standards, they will have their status adjusted. But it takes time, because bureaucracy, delays, the process isn't immediate. And so the understanding is that, like, on that day, 366, most refugees won't have their status adjusted. And so it has never been the understanding that on day 370, if a refugee doesn't have his or her status adjusted to lawful permanent resident, that it almost would seem absurd that you would want to arrest or detain them. Like that runs contrary to the entire purpose of the program. But for the Trump administration, this is essentially a way of being able to round up people we don't want to be here. And Judge Tunham literally, you could tell, was very offended at this. And in his opinion on Friday said the new policy turns the refugees' American dream into a dystopian nightmare.
I'm glad that you've quoted the judge directly. I am wondering, as someone who doesn't read judges' orders all the time, have you noticed over the last year that the tone of judges in their opinions has changed?
Yes.
I get the sense that it looks like these judges are deeply offended, are angry at the absurdities that they seem to be facing.
No, I think they are. I think that's true. And I think they are getting more and more angry. And I think they are getting more and more convinced that they have an important, historic, constitutional role to play. Now, many of them have always thought that. Like, it's not like that was new, but like they didn't think they were going to be playing it in this way. But many of them truly seem to be up to it. And I think in Minnesota specifically, they've been dealing with Operation Metro Surge, and they have been dealing with the overwhelming number of habeas cases filed by people and their lawyers who say they're being improperly detained, improperly arrested, improperly sent out of state, aren't getting their personal effects back, identification documents back after they are released, and the chief judge in Minnesota, Judge Schiltz, who was a George W. Bush appointee, has very much taken the lead for his district. And he's the judge who back in January issued the order detailing the list of cases where ICE had violated court orders. He apparently, the Daniel Rosen, the U.S. attorney who Trump appointed for Minnesota, who had never been a prosecutor, had been mainly an eminent domain lawyer prior to be appointed the U.S. attorney. He was mad at this January order from Judge Schiltz and wrote back to him and basically was like, what you've accused us of is beyond the pale. And I don't believe we knew about this email, and it's kind of until this week, and it is kind of a shocking thing for a U.S. attorney to email the chief judge. It wasn't filed on the docket that I know of. But again, it would have been one of those cases where unless you went to the courthouse, you wouldn't be able to access it. So that's Chris Geidner's other issue. But back to Judge Schiltz's response, he basically said, like, okay, U.S. Attorney Rosen, you're accusing my order of like going beyond the pale and accusing us of things we didn't do. Apparently, Daniel Rosen said that we got a representative sample of the 96 orders in 74 cases that Judge Schiltz had cited. And he did that by literally just picking the first 12 cases cited and looking them up, and basically decided that like Schiltz's order was inaccurate. What Schiltz did was thing that any judge should do if a U.S. attorney is going to attack you. He went back and sent the judges of the district back to the drawing board, had them look at it. He asked each judge to revisit the cases that they had submitted, was further reviewed. He then had his clerks look at that second review, and he said that it cuts both ways. It turns out there weren't 96 orders violated, there were 97, but it wasn't 74 cases, it was 66. But then, because you don't want to mess with a federal judge, he then looked forward. And he identified the violations since then, because Rosen insisted to him that efforts we have already been undertaking for weeks have led to considerable improvement, efforts which have apparently gone unrecognized by some on the bench. Which is like a wild thing for the U.S. attorney to say to a federal judge who you're fighting with in court often. Like normally U.S. attorneys want to be like overly nice to the federal judges in their district, to the extent that like, yeah, I'm not going to basically like suffice it to say like, if anything, normally most journalists covering things would say that the U.S. Attorney's Office has too cozy a relationship with the federal judges in the district. Like normally they're like too nice to each other. So like the fact that like he would be so obnoxious is in and of itself like a huge red flag.
I want to make sure that I understand the context of these orders that the Department of Justice or DHS has been refusing to comply with, so that people can understand it's not just a big number of orders refused, but what's at stake. And if I understand it correctly, the orders that they are failing to comply with are things like, do not send this refugee out of state because they have a habeas petition going on. And a habeas petition is to say that they have been detained unlawfully, correct? That's what that means?
Yes. Yeah, it's do not move them. It's release them immediately. It's provide them, release them. Essentially, essentially there's a thing called malicious compliance, which is I'm looking at your order. Like normally when malicious compliance is used, like it's used when you're talking about like bad companies. Like in a corporate lawsuit, there will be malicious compliance, and it's like the situation where like a judge orders a company to turn over like all of the relevant documents, and then you'll hear about a company turning over 3 million documents in hard copy, and they show up with like 30 boxes at the lawyer's office, like the thing you've seen in movies, and like that's malicious compliance. But like we have this horrifying situation in the Trump administration that like it appears that there's malicious compliance from DHS, and so there will be an order to release somebody, and they'll release them without a coat, without their wallet, without their document, in the middle of the night, in the cold. In the Minnesota winter. And so like then they started adding a line like you have to release them and give 2 hours advance notice to their counsel of when and where you're going to release them. And so then you'll have like or they were releasing them in Texas. And so then they would add a requirement that you have to transport them back and release them in the jurisdiction in which they had been confiscated. And so all of these violations, and I do think I'm in a tough position as a reporter because, they are violations of court orders. If a judge tells you to do something, you do something. If you think they're wrong, you appeal it, or you go back to the court and say, we can't do that for reason X, Y, or Z. Please amend the order. That's the way it works. And so these are violations. They violated the court orders. But I do think for rule of law purposes, I think it is important to understand the difference between we're refusing to comply with a court order and we violated a court order. This is not them getting a court order to release person X and them saying we're not going to release person X. That is a violation of the rule of law in addition to a violation of the court order. This is a lot of it is and we've seen this in a lot of these court orders. The judges will write your failure to prepare for the inevitable consequences of sending 3,000 agents into Minnesota with the sufficient legal capacity to deal with that is not my issue as a federal judge, and it's certainly not the people whose rights are being violated with this issue. That is something you need to address. If you need to bring more lawyers in, if you need to bring more ICE officials in to be able to process people better, you need to do that. But that's on you. And I do think, and so it's they are violations of court orders, and they can lead to civil contempt. And when people say, oh, there should be criminal contempt, put them in jail. I want you to understand the difference between civil contempt and criminal contempt. Civil contempt is used to secure compliance with orders. It is something that a judge does within the realm of their way of getting their orders complied with and to protect the people they're trying to protect under their orders. And so when a judge talks about trying to issue a civil contempt order, what they're trying to do is get the person whose relief they're trying to get protected. And so the first civil contempt order that we got in Minnesota was when DOJ, DHS, ICE, CPB, whoever had the ability to take care of it after an order for a person to be released with his identification documents. He was released, but was not given his identification order documents. The judge issued a contempt order and said, you are this lawyer from DOJ who was in front of me, who was subject to the order, is held in civil contempt, and starting 48 hours from now is going to owe $500 a day until this person gets his documents back. And that started in 48 hours, and I think it was starting on a Thursday, the $500 was going to be due, and on Wednesday night, the petitioner in question got their ID documents back, and DOJ was able to file a document saying he got his ID documents back, and the judge was able to say no fines will be levied. And there were a bunch of people who were upset by that and were well, they got away with it. And it's well, you're not understanding the point of civil contempt. And it's also, it's like, it sometimes upsets me a little when people say that, because I'm like, you're kind of missing the trees for the forest. Mm-hmm. You're missing the trees from the forest, because like, you're so interested in punishing the Trump administration from doing wrong that you're missing the point that, like, we want to protect this person and make sure that they get their ID documents back. Like, and they did. And so, like, that's the system working. Like, yes, we need to then also go along with that and challenge Operation Metro Surge and, like, get them out and, like, do all of that. But, like, this case isn't the way to fix that if DOJ and DHS is going to do what the court orders.
Mm-hmm. I forget if it was Judge Schultz or if it was another one of the judges in Minnesota, but they wrote something to the effect of, I can't remember a time, or I cannot find another time in American history when the U.S. government has needed to be threatened over and over and over again with civil contempt. Can you contextualize that for us?
Yeah, I think that was in Judge Schultz's order this week, the one where he responded to Rosen, and he ended that by saying that he will do what's necessary to protect the rule of law, even if that means moving over into criminal contempt, which now criminal contempt is punishment, like. That because of that goes through much more process. You get criminal protections, and it's also a much more complicated situation because the normal way of dealing with criminal contempt, since you're normally not charging the federal government with criminal contempt, is to refer the case to the Department of Justice. There's a provision in federal law for criminal contempt where the judge is allowed to appoint a special prosecutor if necessary. And so in this situation, that's almost surely what would happen. Why this is so extraordinary is that it just doesn't have, like, it is one of those things that, like, the statement does almost speak for itself. Like, a federal judge, these federal judges, certainly in Minnesota, who, like, have been doing their Minnesota thing for decades at this time, some of them, like, we're not thinking that they were going to be in the position where they were going to be spending winter 25-26 explaining to the federal government that they have to follow court orders, needing to jerry-rig court orders so that you're accounting for the ways that you've seen the federal government try to get around court orders in the past. Like, the first version of that, like, we talked about how they've done it in, like, detention cases specifically, with saying you need to return them to the district and stuff. But like, even the thing that, like, we now sort of think of as normal, but like requiring DOJ to issue a status report within like 24 or 48 hours, like, that is not something that happened before 2025. Like, that itself was a reaction from federal judges looking around the country and saying, like, oh, us ordering something doesn't in and of itself mean it's going to be done, at least in the way we expected was obvious from our order. And so we're going to require DOJ, DHS, ICE, whoever's involved in the lawsuit, Doge back in the day, Office of Personnel Management, Office of Management and Budget to file a status report right away, so that we can see what they're doing. And so these judges were doing that. That then gave them more insight into the ways that like government defendants were too narrowly interpreting orders to then lead them to change the way they were doing it. And where Schultz got to and wanted to make clear in his order was like, this has now gone so far that we're to a position that, like, basically any time we issue an order, we have to be thinking about how is the federal government, another branch of the federal government. Like, that's the other thing is, like, this isn't even a rogue state government. Mm-hmm. Like, this is like their co-equal branch. Like, that they have to think each time about how the co-equal branch is going to try to get around things. And I think that Schultz just wanted to, as a prelude to this criminal contempt threat, wanted to basically justify it, wanted to say, like, look, we are not doing this. Like, this is not us as federal judges deciding to, like, be the aggressor. Mm-hmm. Like, this is us as federal judges responding to lawlessness.
So one of the results of this malicious compliance has been at least one refugee died as a result of exposures. There was recently a blind refugee was detained. He was walking with, I think, a shower curtain as a walking stick because he did not have the money for a medically prescribed one. His first interaction with police was to get tased. So he was already in a bad situation when he was handed off to DHS's custody. And then he was left out in the cold, I think in the middle of the night, and died as a result of his exposures to the elements. At what point does the malicious compliance thing justify potential criminal contempt? I mean, we're talking about... Well, I'm not a lawyer, but like that sounds like it manslaughter, maybe. I mean,
you're beyond criminal contempt potentially. There, you're talking about just criminal charges. Mm-hmm. I mean, criminal contempt is punishment for violation of court orders. This is, I mean, like the first criminal contempt area was the flights continuing back last March 15th and 16th when Trump invoked the Alien Enemies Act to send Venezuelans to CICOT in El Salvador. That was when Judge Boasberg tried to start criminal contempt proceedings, which have been stymied by the panels of the D.C. Circuit Court of Appeals. But to your point, like the reality is that is why we're seeing judges doing what they're doing. There were, I mean, I was at a hearing. There's been a series of long-running cases that have essentially merged into one class action case over the treatment of trans people in prison under the Trump administration that were being filed as early as January 2025. And there are questions about retaliation against witnesses in that case. And that case is all of those cases, but the case in question, they're all before Judge Royce Lamberth, who is a Reagan appointee. And I was in court this past week. is appalled at the questions of noncompliance with his own orders to not retaliate, which, like, to be clear, again, this is a situation where, like, that's actually a rule. Mm-hmm. Like, you don't need an order to not retaliate. Like, that's the law. And so, like, on top of that, on February 19th, he had issued an order to what's called a protective order against any further retaliation against these people. And then literally in the days that followed, they submitted a declaration that there was more retaliation. He called them into court, the government into court last Thursday. He ordered the government to respond by next Tuesday with a written filing, and the government is going to be in court next Wednesday morning on a civil contempt hearing. And so I haven't even had time yet to go through them. But in addition to this Minnesota order that came out on Friday night, there was an order in Oregon relating to the treatment of immigration detainees. There was an order in West Virginia relating to treatment actions. I'm not going to say treatment of detainees. I'm going to say actions by immigration enforcement actions, because some of them I think had to do with the way that they're picking up people. But like that's 3 states that had 3 orders on one evening. And then the order from Royce Lamberth and Judge Schiltz threatening criminal contempt and moving forward to a hearing on civil contempt, those were both on Thursday, and I wrote about them at Law Dork. That's 5 orders in the course of 48 hours, in 5 orders in 4 states. It is astounding. It's alarming. It is the good news of it is that these judges are standing up. Judge Schultz, like I said, and as I said, like a bunch of these are Republican appointees. There have been several Trump appointees at the district court level who have pushed back against Trump. And I think the important thing is those district court judges, like, as opposed to, like, we think about, like, the Supreme Court has, like, it's huge issues, the tariff decision aside, and Trump's reaction to it. But the district court judges, like, the important thing to remember is that, like, by and large, even, like, there are some ideologues, like there's the Matthew Kacsmaryk and Reed O'Connor in the Northern District of Texas. There's Eileen Cannon down in Florida. The names we all know about. But by and large, the district court judges, the thing is, they need to deal day in and day out with the facts, with the effects of their rulings, with the facts on the ground, with the way things are playing out. Even once you go up to the Federal Court of Appeals, technically the issues that they're dealing with almost, by and large, an overwhelming percentage are purely legal questions. And certainly once you get up to the Supreme Court, it's almost always about the legal issue. And so it's easier for appellate judges to say, well, and sometimes they say it almost as, not a bit, but as like a justification, they're like, well, we're not worried about the facts of this case. We're worried about the law because this applies across the board. And so they use it as an excuse sometimes for bad actions. But like, I think it also changes the mindset because like you can get more self-serious and like it's more academic, like you're almost like a professor, like the things we used to like tease like Justice Breyer about, like he would like talk at oral arguments for like 10 minutes asking a question, and like Justice Gorsuch does that somewhat too. But like it's also like the way you're not thinking about like the person in front of you. Whereas district court judges, they do. I mean, these district court judges in Minnesota, like those were 74 people who had sued the federal government for a petition for a writ of habeas corpus to be released from detention or to not be detained, to not be arrested, to have their own effects returned to them because they alleged the federal government did something that was either illegal or unconstitutional. And I think that district court judges are just better at seeing that and remembering that. And so we're getting more real responses from them.
So the Trump administration's focus continues in Minnesota, even though a lot of the headlines have kind of accepted Tom Homan's premise that like, oh, ICE is leaving, the mission is over. That's not the case. Arrests are still happening. The people of Minnesota are still interacting with masked thugs, who are not carrying badges or name tapes or anything like that. And frankly, I can't imagine any American being able to tell the difference between ICE and an unlawful militia that has just formed and is wearing random shit that they bought at the Army-Navy store. You've also written recently about a case in Maine, a class action case in Maine, because some of these masked thugs are walking up to people with cameras, and they are saying that, oh, I'm taking your license plate and a photo or video of your face because we're going to put you into this terrorist database. Can you tell us what that case is about and what you expect to happen from it? Is there a terrorist database that legal observers are ending up in right now?
I mean, we don't know. We do think so. There's been some reporting that that in Minnesota that they were trying to track things and keep. I mean, there is this element of. I mean, I have covered the death penalty for a long time, the implementation of the death penalty and the last minute litigation over the death penalty. And one of the things that it was really important to keep in mind in order to understand truly what was going on is the breadth and depth of ways in which incompetence is also present in governance, and that it is very important to always understand that we used to call it the incompetence malevolence scale, and that like some things that happen that like if you want to look at them as like being based on like these bad actors, like you could see them as malevolence, but like if you are actually understanding that like bad government actors can also be bad government actors, that they might just not know how to govern. And so it's important when looking at these things that are going on to understand that like we also know that like a lot of these people that the Trump administration has put in place and who are running things just don't know how to run things. And so like, it's not clear if this is like some super thing like that's like Palantir and Teal backed and like some sci-fi nightmare, or if it's like a signal chat that was like the like JD Vance and the others did early in the administration. Like we like trying to figure out like how much of this is like bluster, how much of this is carefully organized, how much of this is sort of soup cans on a string. We don't know. And so we've got this lawsuit in Maine that I do think a part of the goal is to get some information to through discovery, through like actually figure it out. And so like, and that's why I do think like it's notable that like this lawsuit was filed in Maine, where things are more low key, where there wasn't a huge surge like Minnesota, despite the fact that there was some reporting. I don't know if you remember after Preddy was killed about like potentially him being in a database or something. But you didn't see the lawsuit there. And so I do think that that was like, it's much easier to get into the actual information if the government's not going to be able to like claim, oh, we can't turn anything over because there's an ongoing internal investigation, like all of those situations. And so they found a more clean case in Maine where they can bring this, where they can then ask for documents, ask for information, get declarations from officials saying when Agent X said this on camera and is recorded, what did he mean? And now will need to answer for that. And so like, we'll get information, but I mean, in their lawsuit, it's pretty direct. And it just says like the tracking, the claimed tracking violates the First Amendment rights of free speech, assembly, and association. And it, again, to return to the other point, like it also violates those First Amendment rights against retaliation for expressing your First Amendment rights.
Kris, I could talk to you for forever about this, and I'm very thankful that you've taken the time. The thing that I want to get from every one of my guests is advice for my listeners, for people who are watching this. How is it that the average person who's not a lawyer can go on offense and impose costs on the opposition, who is doing things like violating First Amendment rights, Fourth Amendment rights, these ICE agents threatening people on the street, saying that they're going to end up in a terrorist database. We've got DHS as a department engaging in this malicious compliance, which has gone as far as killing people, freezing them in the cold in Minnesota, which is to say that it's inhumane, I think is probably not a strong enough description. What can the average person do to get into this offensive posture rather than responding and reacting, which is where we've kind of been as a country for the last 10 years? Yeah, no, I think the key ways are unfortunately not sexy. It is knowing who the people are in your community who are willing to do the standing up. That means like being familiar with who is it that files these lawsuits? Who is it that knows what to do and where to go to? Who are the organizations that are tracking observation, are there
paying attention to what's going on. And then, like, to the extent you can, and to the extent that you are not one of the more vulnerable people, understanding who the vulnerable communities are in your community, and being ready to protect them, and to in relation to the main lawsuit, be ready to be there to account for what's going on through recording, through providing declarations. I mean, one of the really important things that I wrote about and it's both horrifying but is important to understand for going on offense, is that it is very clear within Minnesota that after the Renee Goods killing, that there was an effort to make sure that everybody understood at several levels what needed to be in place in case this happened again. Because when it did happen again, many legal entities, from the nonprofit advocacy organizations up to the county and state government, were more ready to act immediately. And we got like the effort to like go to court immediately to make sure that the state and local authorities would be able to access evidence. You had declarations from witnesses to Alex Preddy's killing who provided declarations to the court in ongoing litigation over Operation Metro Surge that day. And while that's, I mean, it is sort of horrifying to think about being in that position. Like, it was important and illustrative to me that I could see the important consequences and ramifications of the work that people in Minnesota had done in the aftermath of Renee Goods' killing, that I think is a testament to the legacy of her killing, that they did not, when people say, like, don't let this pass us by, like, they didn't. And they took action. And so, like, to the extent you can know who those people are who are doing the work ahead of time, who the organizations are, who the advocates are, and who the communities are that might need protecting, I think that puts us all in a better place going forward.
I think what you just said is really profound. Folks should be ready for a larger ICE force to enter their state, their cities. Minnesota is the focus right now, but it's not going to be the focus forever. ICE now has a larger budget than the vast majorities of advanced militaries around the country. They're bigger than the Marine Corps when it comes to budget. So I think that is great advice. People getting to know who the actors are locally, so that when things start happening, they know who to interact with, they know who to get help from, they know who they can help. So thank you for that. Now, Kris, before I let you go, please tell my listeners where they can read more about your work, how they can support your work, and what you're working on right now.
Yeah, just go to Law Dork, www.lawdork.com. I'm there, and subscribe. There's a free option. I'm also on Bluesky at Chris Geidner. Also, there is a Law Dork News account on Bluesky. And I mean, what I'm working on is continuing to track what the administration is doing, and I'm based in DC and cover the Supreme Court. I go to the Supreme Court for arguments often, and I Most of my coverage is related to either the civil rights or civil liberties implications of the law, but sometimes we go astray as needed in this administration.
Well, thanks so much for joining us. I really appreciate it.
Thank you.
What we've been talking about today isn't just about immigration policy. It isn't just about ICE or just DHS. It's about whether institutions still function when they're put under real stress. And it's about the actions that people can take to fight in service of maintaining those institutions. The federal courts are not perfect. Judges are human. Decisions can be wrong. Outcomes can be inconsistent. The process can be slow, painfully slow. But the fact that lawsuits are being filed, the fact that injunctions are being issued, that orders are being written forcing the executive branch to justify its actions under law, and that judges are escalating with threats of civil or even criminal contempt against federal officials, all of that matters. That is constitutional government in motion. And people like Chris Geidner play a critical role in that process by making court filings accessible, by explaining what rulings actually mean, by holding power accountable to the written record. That is what it looks like to choose an institution and to take its side. You don't have to become a legal scholar to defend an institution. You don't have to fight every battle everywhere. You just have to choose. Just start with one. Maybe for you, it's your local library or local journalism. Maybe it's a labor union or your school board. Maybe it's veterans healthcare. But disengagement is not an option. History shows that when institutions collapse, they don't do all of their collapsing at once. They erode, they're hollowed out, they're discredited, they're privatized, they're captured. And when the institutions are compromised, we, the people who those institutions are built to serve, are easier targets for a fascist regime. And the only thing that slows that process down is specialization. It's commitment. It's people who decide that one thing is worth defending, and they put their all into it. The courts are under pressure right now. The rule of law is under pressure. But pressure is not the same thing as collapse. There are still judges standing up and doing their constitutional duty. There are lawyers filing lawsuits on behalf of incredibly brave plaintiffs. Journalists are bringing those stories to light, and citizens are paying attention and demanding justice. Institutions can hold. So as you leave this episode, I want you to think about Snyder's instruction. Choose an institution. Take its side. And then ask yourself, what would it look like to go on offense for it? On Offense is produced by Gina Kim and edited by Victoria Lombardo for the Valor Media Network. To support our work, please visit weareonoffense.com. There you can sign up for our Substack, subscribe to our YouTube page, and make sure that you're downloading and listening to every episode of the podcast on your favorite app. Your support enables us to do this work, and I'm thankful to those of you who are helping to spread the word about this new show. I'll see you next time.